When you
President.
sent a letter to the Office of the Vice President, you attached a copy of the rules
Okay.
in aid of legislation.
Yes po.
Yes, sir. Nakalagay po doon na witnesses lang po ang ino-oath. Sabi niyo po ngayon sa amin, resource persons kami.
Ang ano po, considered as resource person po.
Ang ano po.
Kayo po.
Kaya nga po.
Yes po. Lahat po ino-oath po.
Yes.
Apo.
Nakalagay po sa rules ninyo, witnesses. Nakalagay po dito ngayon sa table, resource persons.
Lahat po considered as resource person and witness. Lahat po naman kayo, lahat resource person pa eh. Wala pa naman po tayong tinatawag na, lahat po considered as resource person pa lang po.
Right. Opo. Ang nasa rules ninyo, witnesses lang po ang nag-o-oath. Wala po kayong rules sa resource persons.
Ma'am, ano lang po yun eh. Yung term lang po yun eh. Pero considered as a resource person din po kayo eh.
Yes, sir.
Opo.
Resource persons nga po
Kayo
nakalagay
witness
dito.
din po at saka resource person po.
Hindi niyo po sinabi na witness ako. Sinabi niyo po dito ngayon, resource persons. Ang nakalagay po sa rules ninyo, witness.
Comsec, ano po yung pinadala po ninyo?
Yun pong rules in aid of legislation.
Mr. Chair, point of order.
What is the point of order of the Honorable
Because
Congressman
this issue about
Macapagal?
witness, resource person, etc., etc.
Ma'am, pakilakas lang po, hindi po marinig.
Persons and accused has been taken up in previous legislative inquiries in aid of legislation. I want to quote a December 8, 2008 hearing in the Senate, where Senator Miriam Defensor Santiago had an opinion on a similar situation, but she quoted a Supreme Court ruling. So, the Constitution provides that no person shall be compelled to be a witness against himself. The Supreme Court has repeatedly emphasized that there is a difference between a mere witness and the accused. And it can appear from statements and privileged speeches that there is that a person who is the subject matter of an adverse privileged speech is not a mere witness or a mere person of interest, meaning a suspect. She is in fact accused of what seems to be a criminal case for violation of certain criminal laws, including malversation of public funds. And there is a case quoted in 2007, Standard Chartered Bank versus the Committee on Banks, where the court repeated the rule that an accused occupies a different tier of protection from an ordinary witness. So, where the court said, Supreme Court said, whereas an ordinary witness may be compelled to take the witness stand and claim the privilege at each question requiring an incriminating answer is shot at him, an accused may altogether refuse to take the witness stand and refuse to answer any or all questions. So that has been a supreme. And then there is a portion that the court explained that the right of the accused against self-incrimination also applies to respondents in administrative investigations such as legislative inquiries in aid of legislation. So that is the point of order I am raising, and there is a Supreme Court ruling to this effect. Thank you, Mr.
With that, the chair declares 1 minute suspension. Recess.